Hello, and welcome to the LLG Grapevine podcast. You're listening this week to Dennis Hall, LLG Bulletin Editor. Well, it's been a busy week once again, with much to add to the bulletin. So let's get straight on with my first item. It is perhaps a little ironic that the Tate Modern Gallery found itself in court last week, not for what you can see inside the gallery, but for what you can see outside. In the case of Fern against the Board of Trustees of the Tate Gallery, the Supreme Court held that it is possible, as a matter of principle, for a private nuisance to exist where residential property is subject to visual intrusion. The owners of luxury flats opposite Tate Modern's viewing gallery face an unacceptable level of intrusion that prevents them enjoying their homes, the Supreme Court has ruled. Now, let's examine the legal principles involved in this case. A nuisance is a use of land which wrongfully interferes with the ordinary use and enjoyment of neighbouring land. To amount to a nuisance, the interference must be substantial, judged by the standards of the ordinary person. Even where there is a substantial interference, the defendant will not be liable if it is doing no more than making a common and ordinary use of its land. But what constitutes an ordinary use of land is to be judged having regard to the character of the locality, for example, whether it is a residential or an industrial area. And it is no answer to a claim for nuisance to say that the defendant is using its land reasonably or in a way that is beneficial to the public. In deciding whether one person's use of land has infringed another's rights, the public utility of the conflicting uses is not relevant. The benefit of land use to the wider community may be considered in deciding what remedy to grant, and may justify awarding damages rather than granting an injunction. But it does not justify denying a victim any remedy at all. Now, the judgment of the Supreme Court does not contain a remedy, and this issue was deferred to the High Court, suggesting it may involve either an injunction or damages paid to the owners. And looking ahead, it will be interesting to see whether this case triggers more property owners to making similar claims where they feel they are overlooked. Next, it is reported that firms accused of creating toxic culture will be hauled before the Solicitors' Disciplinary Tribunal. Firms failing to create a safe working environment will still have to face a hearing before the Solicitors' Disciplinary Tribunal, regulators have stated. A joint statement published by the Solicitors' Disciplinary Tribunal and the Solicitors' Regulation Authority effectively suggests that this type of misconduct will usually incur fines of more than £25,000 if it is found proven. The organisations this week issued a joint statement on referrals to the tribunal in the light of the SRA's new power to fine firms and solicitors up to £25,000. And note that alternative business structures can be fined up to £250 million by the SRA. Such increased scope for issuing penalties will inevitably reduce the tribunal's workload as more cases are dealt with by the regulator, which decides what matters should be referred. But the statement makes clear that the Solicitors' Disciplinary Tribunal will continue to hear the most serious cases of individual professional misconduct. Examples of cases that should typically be referred to the tribunal include a failure by a firm to take appropriate steps to protect an employee from counter-inclusive misconduct, which is defined as conduct which intentionally or unintentionally denies opportunities because of their background or characteristics. The statement says referrals will be made where there is evidence of firms creating a pervasive, toxic culture, as well as those whose failure to comply with regulations causes harm to clients or employees. Now, the disciplinary tribunal will also hear cases involving allegations of sexual misconduct, racism, bullying, or harassment. Cases involving more than one respondent, those of high public interest, and those which involve a novel point of law are all likely to be heard in the tribunal. And the statement added, the SRA's increased fining powers now mean there is an opportunity to make sure that cases are not referred to the tribunal unnecessarily. It might now be able to deal with cases at a higher level of seriousness than previously. Cases involving a material dispute between the parties that can only be resolved through an oral hearing should be referred to the tribunal, save for applications relating to licensed bodies. And the statement added that not only does the tribunal have the relevant experience and capability to deal with these cases, this clearly meets the SRA's open justice and public interest objectives. So, how would you characterize your own working environment? We all know that some are better than others, and usually we know why. I turn now to the impact of Brexit. The aftermath following Brexit is beset with many difficulties for both government and Parliament. The scale of what needs to be done is one thing, but the eagerness to dispense with EU law may lead to the loss of legal relaxations that actually benefit our sector, not least in the complex world of procurement. Let me explain why in this instance. The procurement bill has recently received further scrutiny at committee stage in the House of Commons, and the LGA has already submitted written evidence to the bill committee. The LGA have consistently raised concerns about the wording of the bill, which could significantly limit public bodies, including local authorities, from using the current vertical and horizontal procurement exemptions, which enable councils and public sector bodies to enter into collaborative arrangements to run efficient public services. And one of these examples used to be known, you may recall, as the topical case exemption. The bill introduced a new reasonableness test, which stipulated that these exemptions cannot be used if the goods, services or works representing the main purpose of the contract could reasonably be supplied under a separate contract. As it will often be the case that public services could reasonably be supplied by a provider that is not a public entity, the legislation could have been interpreted as requiring the public sector to have to engage the market, even for arrangements wholly within the public sector. However, the LGA are pleased to note that following their engagement, the government introduced amendments 85 and 86, which resolved these concerns. These amendments were passed by MPs last Tuesday. Cabinet Office Minister Alex Burghardt MP said that the original bill did not close down the exemptions. However, to aid understanding of the legislation, the government have redrafted Schedule 2 so that Part 1 will now cover the vertical and horizontal exemptions, and Part 2 will list the categories of goods and services that are either completely exempt or covered by other procurement legislation, like, for example, NHS clinical services. And the reasonableness test will only apply to Part 2, meaning that the vertical and horizontal exemptions will be unaffected by this wording. Now, this is a timely opportunity then to remind you that the LLG Online Commercial Conference takes place on the 30th of March. One of the UK's biggest trade unions has formally established a branch for judges as it demands answers from the Lord Chief Justice over a toxic work environment reportedly leaving some members feeling suicidal. At a meeting this week attended by Shadow Justice Secretary Steve Reed MP, the GMB formally constituted the GMB's Judges Branch. A motion concerning the treatment of judges, discrimination, and so-called secret soundings was also passed. If the motion is passed at GMB Congress in June, it will be adopted as national policy. GMB senior organiser Stuart Fegan described the official establishment of the branch as an historic moment. He has written to the Lord Chief Justice, Lord Burnett, expressing concerns about an allegedly toxic work environment. The letter says, "Our members have informed me that initiatives advertised internally purporting to address well-being are at best tokenistic, with recent published diversity policies not containing any plan to improve workplace experience or culture. The judicial leadership have attempted to introduce an ill health policy that would, in the view of our members," he says, "operate unlawfully to diminish their rights in the workplace, which is encouraging low confidence in the ability or willingness of the judicial leadership to address the welfare of judges." And the union is particularly concerned about the significant number of judges who have reported bullying and harassment in their courts. Last month, the judiciary published a statement of expected behaviour after research found allegations of bullying, harassment and discrimination. Judges will also receive training on avoiding inappropriate behaviour. Now, this is an extraordinary report, and we will look to see how this union initiative develops over the coming months. And my final item this week turns to the Levelling Up Bill. The scale and breadth of the Levelling Up Bill currently before Parliament has been its main problem. It's just too big to digest in one go. Now, the Levelling Up Committee has just decided that the bill's planning provisions need a much closer look. The Levelling Up Committee has said that it will examine the government's current consultation on reforms to national planning policy, looking at the proposed changes in particular to the National Planning Policy Framework and the government's wider approach to planning reform. The committee's scrutiny of the reforms to national planning policy is expected to open with an evidence session with planning, local authority and housing stakeholders. This evidence session is likely to be scheduled in March, after the deadline of the 2nd of March for the government's own consultation. Now, the committee is expected to examine the government's proposed changes to the NPPF, the approach to developing national development management policies, and other proposals for planning reform resulting from the Levelling Up and Regeneration Bill. Clive Betts, chair of the Levelling Up Committee, said, "The government's consultation on reforms to national planning policy raises a series of issues in areas such as these new national policies and how they might affect the primacy of local plans, as well as questions around local housing need, the stated commitment to the housing target, and how this is supported by local plans." Last week, it was revealed that at least 7 local authorities have paused the passage of their local plan, citing the government's consultation. And the flurry of postponements came as a result of the government's proposed planning law reforms that suggest making it clearer that the standard method for housing need is an advisory starting point only, and that councils are not required to review greenbelt boundaries if this would be the only way to meet their housing targets, among other changes. Well, that's me done for this week. You can read more on the items discussed today and many more besides by going to Bulletin number 5, available now on the LLG website. So it's goodbye from me and have a good week.